To initial public comment. Do you have cards?
I have lots of cards, Mr. Chairman.
All right. Thank you.
Jeannie Nix, followed by Katie Calling.
Good morning, Mr. Chairman and distinguished members of the board. My name is Jeannie Nix. I'm here today to speak about my concern regarding the NDAA's authorization of indefinite detention and assassination of any person on U.S. soil under military detention without charge, trial, or access to legal counsel. Within the Declaration of Independence, the founders of our nation cited numerous tyrannical acts which led them to revolt against the British Crown, including, but not limited to, the obstruction of the administration of justice, affecting to render the military superior to civil power, subjecting colonists to foreign jurisdictions and then trying them under different laws overseas for pretend offenses, depriving them of trial by jury, and waging war against them. In reading sections 1021 and 1022 of the NDAA, one can make many comparisons with some of the reasons our founding fathers decided to revolt against a standing British Army, the most powerful of its day. Further, many military families have sacrificed, and 1.3 million Americans have died fighting to protect the freedom and liberty which they've bestowed upon us. Now it's our turn to stand up and defend those liberties so that the next generation will be able to enjoy the same freedoms we have. According to the 10th Amendment Center's website, in 2012 there were 17 county and local governments which took up anti-NDAA resolutions. So far in 2013 there are 17 county and local governments identified which are at some stage of working on anti-NDAA resolutions. On Tuesday, February 12th, 2013, the City of San Francisco Board of Supervisors introduced an anti-NDAA resolution, which has been agendized for their meeting scheduled for today. If cities like San Francisco are willing to take the NDAA seriously and propose anti-NDAA resolution, then why shouldn't this board do the same?
Katie Calling, followed by Jean Gardella.
Good morning, Mr. Chairman and members of the Commission. My name is Katie Calling. I'm a little nervous, so bear with me. The NDAA 2012 in sections 1021 and 1022 declared the United States as part of the battlefield in the War on Terror. On the battlefield, military law takes precedent over civilian law. This is a ridiculous and unnecessary act for Congress to take. Both the 2012 and 2013 versions of the NDAA received overwhelming bipartisan support in both the House and Senate. In fact, the pre-conference report version of the NDAA 2013 passed the House of Representatives 299 to 120, and the Senate version passed unanimously. I have given up on Congress's ability and desire to fix the problem and threat to our civil liberties. Congress clearly had an opportunity to repeal or amend sections 1021 and 1022, or to clarify the language within those sections while working on the NDAA, but failed to do so in any significant way. In fact, on Congressman Amadei's website, there can be found an analysis of the NDAA, which relies on tricky and misleading language within certain sections to sell to his constituents. These sections generally lead the average person to believe that the NDAA does not affect them. However, from a legal perspective, these sections hold little or no real merit. As I do not see a terrorist standing on every street corner, I see no need for the federal government to destroy my civil liberties and gut the Constitution in the name of protection. You cannot protect me by taking away my rights. I believe that we need to work from the ground up at the state and local levels if we are going to defend our inalienable rights recognized within the Constitution. If Congress is unlikely to fix the problem, then we must rely on you and the Sheriff's Department to preserve and protect our rights. I urge the County Commission and Sheriff to work with PANDA to draft a meaningful resolution that is acceptable to all stakeholders.
Carol Feinberg, followed by Bert Tilson.
Good morning, County Commissioners. I'm here today to speak out against National Defense Authorization Act. On its face, it funds the military, and it has been around for over 4 decades. But in the NDAA of 2012 and 2013, drastic measures have been introduced that virtually wipe out the First Amendment, the Fourth Amendment, the Fifth Amendment, and the 10th Amendment. The federal government now has the authority to arrest, detain, and even kill American citizens without due process if they are deemed to be engaging in unsavory activity. The definitions are so loose, the parameters so broad, that it is feasible I can be picked up for attending a Tea Party meeting or a pro-Second Amendment rally, or anything this pro-socialist federal administration deems is not to its liking. Last I checked, I'm an American taxpayer. My taxes go to pay your salaries. My vote allows you to sit there, allows the DA to sit in the DA's chair, and allows the sheriff to wear a badge on his chest. I represent 150 like-minded individuals in a constitutionally conservative group who meet bi-monthly and who are not sitting by idly while our country is instituting policies that avert our rights and trample the Constitution of the United States of America. We will not sit idly by while our country institute policies that are even closer to ever closer to a third world dictatorship or Nazi Germany. 30,000 unmanned drones surveilling U.S. citizens, smart grids, smart meters, smart appliances that monitor and control our electric and gas usage, widgets on our emails that monitor our internet activity, and now NDAA. This is not the America I want to live in, and you shouldn't either. Pledges and oaths were taken to uphold the Constitution. I urge you to read the NDAA of 2012 and 2013. I beg and plead with you to implement a resolution nullifying this abusive and far-reaching bill in our county. Thank you.
Bert Tilson, followed by Valerie Tilson.
Hello, my name is Bert Tilson. I'd like to speak to you about the NDAA, National Defense Authorization Act. It has me concerned for the following reasons. By the government's own definition, I'm classified as a quote-unquote potential terrorist. The reason for this classification is I own guns and ammunition. I don't agree with everything the government tells me or does. I believe in being prepared, so I have more than 7 days of food in my home. I vote for the third party when I feel they are best qualified for the position. I feel these are not things that should be held against me, and I have concern over whether or not someone in government will at any time pick my name for pick up as a terrorist and make me disappear with no legal recourse or civil rights whatsoever. I've been a security officer and a private investigator for about 35 years. I've been a law-abiding citizen all my life. And yet every day I worry about whether or not I will be running errands and get pulled over and be disappeared. What will happen to my wife? Will she be informed as to where my whereabouts? Or will I be home watching TV and have someone come barging through the front door to take me away? I don't like these thoughts. I don't feel that I should have to be subjected to the concerns I have briefly outlined to you about the NDAA. I'm a firm believer in the Constitution. I feel that this law is unconstitutional. Some of the reasons for terrorists: criticizing the federal government, using cash to purchase things, storing food and medical supplies, owning a firearm and storing ammunition, standing still and minding your own business near a government building, writing down something on a piece of paper near a government building, using a pair of binoculars, protesting for animal rights in front of a medical lab. Thank you.
Thank you.
Paul Lennar, followed by F. Stephen Donahue.
Yeah, my name is Paul Lennar, and I'm also here to speak in favor of the county commission working with PANDA to exempt ourselves, to secede from, if necessary, enforcement of the NDAA. I'm a member of an organization, the Industrial Workers of the World, who has some long experience with the suppression of civil liberties under the guise of national security. Going back to the Palmer raids of 1919, when unions were crushed with the excuse that, well, you know, we just had a war with Germany and these guys are Kaiser supporters because they weren't in favor of the war. That was bull then, it's bull now. The fact that I'm going to use my civil liberties to go ahead and speak my mind does not make me a terrorist, and I shall not be treated as such, nor will the rest of my membership. It's been a long time since the days when the local Chamber of Commerce used to string wobblies up. Wobbly is a name for IWW members. And it's kind of funny that now I'm in the reverse position. Because the county commission and city government are those organs of government closest to the people and most directly able to be influenced by the people, it is incumbent upon them to work with people who are aware of these threats to our basic liberties to go ahead and make sure that there is no cooperation, none, with any federal law like the NDAA, which will abridge them. Thank you.
F. Stephen Donahue, followed by Mark Raber. Mr. Donahue? And are you Mark Raber then? Ray Dow, thank you. I couldn't read your handwriting. Go ahead.
My name is Mark Radow, and I appreciate the opportunity to speak to the chairman, the vice chairman, and the commission. My purpose is to speak out against the NDAA and to acknowledge and support the efforts of a group known as PANDA in opposition to the NDAA. Many have prepared text and read prepared text for you. I view liberty not as prepared text, but rather an elemental freedom granted to all of us some 200 years ago. Liberty is to do as we see fit for ourselves without fear of government tyranny. I understand that this commission may have influence over the local government and our sheriff, who can nullify the effect of the NDAA, and I hope that you will do everything you can within your power to nullify its effect on the people here in this county that you represent. Thank you.
Joanna Schumacher, followed by Maria Berg.
For the record, I'm Joanna Schumacher. I live in Washoe County, and I'm here on behalf of a large bipartisan group who are unable to be here today. We wish to see positive action by those who have been elected to serve and protect us, and this also means protection from a tyrannical federal government. This is the case with NDAA. The NDAA is filled with gross violations against my constitutionally protected, God-given rights. I urge the County of Washoe to do your job, to protect and serve us, give this matter the time on your agenda it deserves, and implement a resolution to nullify the NDAA within the borders of Washoe County. Thank you.
Christopher Corbett, followed by Joe Taglieber.
Good morning. Before I begin, I'd just like to ask for clarification from the chair, if I might. I had received an email yesterday indicating the possibility of speaking for 5 minutes during public comment or 2 minutes with questions, and I just wasn't sure. I wanted to clarify what the choice was there.
Do you represent a group?
PANDA, People Against the National Defense Authorization Act, the NDAA.
And have they selected you to speak?
Have they selected me to speak? Well, I guess they have, because I'm the Nevada State Coordinator for that organization.
Okay. If there's a group, one person from the group gets 5 minutes. That's a general rule.
Okay. Well, there's
So
other
if you're
people.
that person, you can take 5
Okay,
minutes.
but there's other people who have showed up here of their own accord that may wish to also speak further.
They get 2 minutes.
Okay,
Each.
great. All right, thank you. Stand up. Stand up, please. Thank you.
Sir, we're not doing demonstrations. If you want to speak, then speak.
Thank you.
We're not going to accept applause. If you want a nice, lengthy recess, we'll be happy to accommodate you.
Now, we don't want to cause
Speak
problems. We're trying
if
to
you want to speak.
Thank you. Honorable Washoe County Commission, my name is Christopher Corbett, Nevada State Coordinator for PANDA. I'd like to state my disappointment over the lack of forewarning of the agendizing of PANDA's proposed anti-NDAA resolution. It was our understanding that the opponents of our resolution were not the least bit happy with the resolution we submitted. We had no reason to believe nor expect our resolution to be agendized. I was only notified on the day of the Commission meeting at 11:10 a.m. that the Board was discussing a proposed resolution. Not having a voice in the conversation now places us in an awkward position. I would like to thank Commissioner Jung for doing the heavy lifting in the discussion of the NDAA and Deputy DA Liparelli for at least digging deeper into the facts of the NDAA, lending an air of legitimacy to our concerns. With all due respect to the DA and the Sheriff, the DA's argument is fundamentally unsound. The Nevada legislative oath is in 4 parts: to uphold and defend the Constitution, government, Nevada Constitution, and Nevada government. The order of the oath is important and places the oath to the Constitution above the other parts of the oath. To paraphrase Article 6, Section 2 of the Constitution, this Constitution and federal laws made in pursuance thereof shall be the supreme law of the land. Clearly, any law which authorizes indefinite detention without trial is not a law made in pursuance of the Constitution. The Supreme Court in Marbury v. Madison held that an unconstitutional federal law is null and void from its inception. Also, contrary to the DA's testimony of his lack of knowledge of any ruling of the NDAA being unconstitutional, in Hedges v. Obama, Federal Court Judge Catherine Forrest has done just that by placing a permanent injunction on the NDAA's unconstitutional authorizations. Less than 24 hours later, federal attorneys had already filed an emergency appeal and requested an emergency hearing pending appeal after federal attorneys, emergency hearing in which they received the following business day. The government was granted a stay of the injunction pending appeal after federal attorneys stated the injunction would do irreparable harm to the United States. The quick filing and request for an emergency hearing has led critics to believe that the government is already detaining people under the NDAA and was in contempt of court under the injunction. However, the courts are not a likely avenue of solution for the average citizen without standing, and under the NDAA, the courts are unavailable to a person with standing, a classic catch-22. Further, for the DA to prioritize collaboration of county law enforcement with outside agencies above the constitutional rights of citizens is out of order and a violation of the Nevada legislative oath. For the record, I previously made an effort to reach out to the DA and requested a meeting to discuss the proposed resolution, the NDAA, and any concerns the DA may have had, but I was soundly turned down. Also, the sheriff is the supreme law enforcement officer within the county and has the constitutional authority to deny federal law enforcement agencies to act under the NDAA within Washoe County. Permitting operations under the NDAA within the county would again be out of order and a violation of his sworn oath. Ironically, on February 12, 2013, while PANDA's proposed resolution was being thrown under the bus by Washoe County, the Board of Supervisors of the City of San Francisco were also taking notice of the NDAA, and a resolution of noncompliance was introduced before the Board, which identifies 6 sponsors. It appears the City of San Francisco, unlike Washoe County, is concerned enough by the threat posed to civil liberties by the NDAA to take action to protect their citizens and residents. Apparently, the NDAA is within their purview. As I stand here before you today, trying to regain some traction and footing, the City of San Francisco Board of Supervisors is preparing to discuss their proposed anti-NDAA resolution. We could be doing the same thing, but instead we are here still trying to get you to hear our concerns, to take them seriously, and to take action. Congress had an opportunity to repeal or amend Sections 1021 and 1022 of H.R. 1540 while working on NDAA 2013, but didn't do so. That and the overwhelming bipartisan support for the bill in Congress leave little expectation that we can expect Congress to do so in the future. So we are left to look towards the state and county levels of government to interpose on our behalf. However, apparently the majority of this board, the DA and the sheriff, don't like PANDA's proposed noncompliance resolution. We can remove the cover page with the web address, which was never intended to be a part of the resolution to begin with. We can amend and or omit some of the language within it. There are a number of things that we can do to hash this out and put together a workable document. In closing, we have brought several supporting documents and pocket constitutions for your reference. We hope to work with all parties to draft a meaningful resolution which doesn't impose upon parties but which represents the level of concern with which we have and Commissioners Jung and Weber have also spoken to. Further, we ask you to support BDR 728, the Nevada Liberty Preservation Act, at the state legislature. Thank you.
Joe Taglieber, followed by Dr. Tom Morris.
Morning, Commission members. Thank you for allowing us to speak today. It has come to my attention that the County Commission wants to promote increased public participation. Among the many opportunities to improve openness and access, the County Commission should look closely at its rules regarding public comment. Open meeting laws were established to promote the effective participation of citizens in government. The Attorney General of Nevada enforces the mandates of the Open Meeting Law. The Open Meeting Law Manual, published July 2012, is a guide written to assist public bodies in administering public meetings that are conducive to open participation by all. This is from the Open Meeting Laws, August 26, 1999. The Office of the Attorney General believes that any practice or policy that discourages participation, even if technically in compliance with the law, may violate the spirit of the Open Meeting Law. Any violation of the spirit, not just the letter of the Open Meeting Laws, have the effect of stifling our fundamental right to participate in government. Two passages from the OMLM that I would like to draw your attention to that I feel the county has been in violation of the spirit of the Open Meeting Law. One, contrary to the impression that I have been left with based on comments from this board and others, elected officials are allowed to discuss issues raised during periods of public comment. This is from page 81 of the manual. Allows, NRS 241.020 allows discussion of public comment with the public body. Public body may not inform the public that it is legally prohibited from discussing public comments either amongst themselves or with speakers from the public. NRS 241 clearly allows discussion with members of the public. I was under the impression, based on statements from this body and others in the state, that members were not allowed to make or were not allowed to discuss public comment. This passage clearly says otherwise. And as a frequent public commenter, I felt that I have always been pressured and stifled to keep my comment under 2 minutes.
Dr. Tom Morris, followed by Ted Haviter.
Yes, Commissioners. Guantanamo forever. In his inaugural address, President Obama called on us to reject as false the choice between our safety and our ideals. We agree. Now, to protect both, he must repeal the NDAA that was passed recently by Congress. This budget bill, which can be repealed without cutting financing of our troops, is both misguided and unnecessary. The President already has the power and flexibility to effectively fight terrorism. One provision would authorize the military to indefinitely detain without charge people suspected of involvement with terrorism, including United States citizens apprehended on American soil. Due process would be a thing of the past. Some claim that this provision would merely codify existing practice. Current law empowers the military to detain people caught on the battlefield, but this provision would expand the battlefield to include the United States and hand Osama bin Laden an unearned victory long after his well-earned demise. A second provision would mandate military custody for most terrorism suspects. It would force on the military responsibilities it hasn't sought. This would violate not only the spirit of the Post-Reconstruction Act, limiting the use of the armed forces for domestic law enforcement, but also our trust with service members who enlist believing that they will never be asked to turn their weapons upon fellow Americans. It would sideline the work of the FBI and local law enforcement agencies in domestic counterterrorism. Mandatory military custody would reduce, if not eliminate, the role of federal courts in terrorism cases. This NDAA must be repealed. There's no question about it. We are all for PANDA's recommendation in this regard. Thanks very much.
Thank you, Doctor.
Ted Haviter, followed by Stephen Donahue.
Thank you, Ted Levater, Commissioners. I just want to be clear what we're here asking for today. We are here in an effort to still work with the County Commission on drafting a resolution that's amicable to all parties. We're more than willing to back away from our original resolution and hope to find something that we can all agree on. Despite that, I would still like to address some of the concerns that were brought up at last meeting regarding our specific resolution. Commissioner Burke-Bigler was concerned about the extensiveness of our resolution. It is very extensive, and that reflects the amount of time and effort we've put into it. And we are happy to provide that research and additional resources to the county. To start with, we're providing copies of the Nevada Constitution and the U.S. Constitution so you can review our resolution to see that we do have standing. Commissioner Humke, on 2 occasions, raised concerns about the odd language in our resolution, specifically regarding the request to watch a YouTube video. Unfortunately, that language was not part of our resolution, but it was only part of the cover page. It adds to the comments by Commissioner Young that staff report was rather odd, and I'm concerned it had the unintentional effect of biasing your discussion. Most importantly, I would like to address Commissioner Hartog's concerns that this is not within the purview of the Washoe County Commission to deal with this issue. Commissioner Hartog compared You're welcome. He compared it to constituents asking for help with the price of gas. I've read the oath of office that the commissioners take. While it says nothing about the cost of fossil fuels, it does state that you will protect and defend the Constitution of the United States. At a minimum, the 2012 NDAA is a step towards establishing the legal justification for indefinite military detention without charge or trial of any person on U.S. soil. I just want you to take a minute and think for yourself. When you hear the words indefinite detention without charge or trial, is that consistent with your understanding of the Constitution you took an oath to defend? We're asking you to stand with us today to defend that oath. We would appreciate your comments on our public comment today. Thank you.
Stephen Donahue?
Good morning. I'm Steve Donahue, and I live in the Galena area of Washoe County. And I brought my Constitution, but I guess they're going to give you one anyway, and I'm sure you've already read it. I have to stand behind the folks from the NDAA. I'm speaking individually and not as a board member of the Nevada Republican Party, but I'm speaking personally as a resident of Washoe County. As far as I'm concerned, the sheriff is the absolute sovereign out there in law enforcement, and that you have the authority to guide him, perhaps, in what he should do about this. This is unconstitutional. When it first passed, I spoke to Mark Amadei the same day it passed, and he said, "Don't worry, Steve, they're going to change the wording right after the first of the year." And guess what? It was never brought up again. So we have certain people from other parts of the country who think that the federal government is the supreme government of the land. But fortunately in Nevada, we know that the states trump the feds. And you as a local government, you trump what goes on in this county. So I want to encourage all of you to discuss this, to let the people know that you stand behind the Constitution of the United States. That's the most important document. Hundreds of thousands of men are out in the field all over the world today defending this document. And we need you to do it right here in Reno. Thank you.
Mr. Chairman, that was all the comment cards I had.
Thank you very much. We will close, therefore, initial public comment and move on to the next item. Madam Manager.
Thank you, Mr. Chairman. Next item is Commissioners' Managers' Announcements, requests for information, topics for future agendas, statements relating to items not on the agenda, and any ideas and suggestions for greater efficiency, cost effectiveness, and innovation in county government. No discussion among commissioners will take place on this item.
Thank you very much. I believe it is the turn of the right side of the board to start. Commissioner Burke-Bigler.
Thank you, Mr. Chairman. I know at one time in the past we had a discussion about extending our period of time for public comment from 2 minutes to 3 minutes, and I'd like to bring that, to request that would be on a future agenda, that we have that discussion publicly so that we have the opportunity to address it again. And secondly, having heard the comments from the PANDA group, I wonder if perhaps it might not be a good idea if we bring that back, although I didn't vote in favor of bringing it back. I did not second in favor of bringing it back, but I wonder if perhaps it might not be a good idea to bring it back to the commission and have us take the opportunity to discuss it one more time. Thank you.
Thank you, Commissioner Weber.
Thank you. I'm in agreement as well to bring this back as an item, the PANDA resolution. And also, I don't know when that would be, but I'm sure our manager will get it on an agenda. And then I also wanted to share that the Sparks Justice Court had their grand opening last Friday, and it was a very nice event. But I also want to say thank you to so many people who made this all possible. And Commissioner Larkin was there as well. Former Commissioner Larkin was at the event, and it was very well attended. And if you haven't been to the Sparks Justice Court, as the court administrator said, you just need to get a traffic violation, and you can be right there at the Sparks Justice Court to see it for yourself. So it's a great venue, and much better than where the Sparks Justice Court previously has been for the last 17 years, 14 years. So just wanted to share, it's a great place for safety, security of this Justice Court. Thank you.
Thank you, Commissioner Jung.
Thank you, Mr. Chairman. I would volunteer, if that's the spirit of this board, to help construct a dialogue with the appropriate parties about this PANDA resolution, and hopefully have a give and take between the citizen activists and our district attorney's office as well as our sheriff's office, mindful that those are elected officials and they are in charge of themselves, but I would be very happy to serve as the facilitator and the liaison to perhaps come to some resolution. It might be a resolution that will be more educational than strident, perhaps. I mean, that's the way I'm seeing this going at this point, but I'm happy to take that on and then alert the chair as to when it's ripe for a public discussion, and that we've reached the consensus, and hopefully consensus, and can pursue it there. Thank you, Mr. Chairman.